can you hear me okay?
Yes, Your Honor.
Yes, Your Honor, I can.
All right. Thank you very much. A couple of things before I call the case. Just so you know, counsel, I've got two monitors up. I'm taking notes to the side. If you see me looking away, that is what is happening. For the record, this is the time set for oral argument on an application for attorney's fees and costs. The case number is CV2026-003723. It is Thomas and Cynthia Mazzetta against the Country Club at DC Ranch, Inc. And let me begin with appearances, starting with counsel for the plaintiffs, Mr. Walsh.
Yes, Your Honor. Jeffrey Walsh, and also on the call is Adriana Gorton, and we represent the plaintiffs, Thomas and Cynthia Mazzetta.
Thank you, counsel. Good morning, Ms. Gorton. And Mr. Gear for the defendant.
Good morning, Your Honor. Eric Gear with Spencer Fain. With me today is Dina Awad, and we are counsel for the defendant.
Thank you, and good morning, Ms. Awad. All right, gentlemen, I've gone back through the case file, so I am reasonably up to date on everything that has happened since the filing of the complaint. I know that the briefing occurred while Judge Gordon was managing the case, but I have considered the application, the response, and the reply. Before we get to the argument proper, anything that the parties would like to apprise the court of at this time? Mr. Walsh?
Nothing, Your Honor. We're ready to proceed.
All right. Mr. Garrett?
Nothing, Your Honor, but if I could clarify before we begin, what amount of time are the parties allotted for today's oral argument?
It's not going to be more than 10 or 15 minutes each. I think 15 minutes tops.
Thank you, Your Honor. I'll try to reserve some time for rebuttal.
That's perfectly fine. All right. Mr. Garrett, here it is, your application. Why don't you take us out?
Thank you very much, Your Honor. Defendants request that the court grant its application for attorney's fees and costs and award the defendants $149,707 in reasonable attorney's fees and $3,902.69 in taxable costs. Importantly, Your Honor, there's no dispute in this case that this is a contested action arising out of contract and that fees are eligible under ARS 1234101. The only real remaining issues in dispute is whether this court should exercise its discretion and award defendants their reasonable attorney's fees, and if so, how much should be awarded. Let me start, Your Honor, with what guides the court in the exercise of its discretion. We submit there are two factors that the court really should consider. Number one is the purposes behind Arizona's fee statute, and then number two is obviously the China doll factors. Here, both weigh heavily in favor of awarding defendants their attorney's fees in this case where plaintiffs rushed to court, demanded an injunction, put the parties through a significant amount of work litigating that injunction, and then voluntarily dismissed its case on the eve of argument on a dispositive motion to dismiss. I'll submit to the court first on the purposes of the statute. Those are to mitigate the burden and expense of litigation, to encourage more careful analysis prior to filing suit, and promote settlement prior to litigation. Here, plaintiff elected litigation over settlement and careful analysis of its claim, and an award of fees is appropriate and necessary to mitigate the burden and expense caused by that decision. Importantly, Your Honor, the history of this case doesn't start on the date the complaint was filed. As we set forth in our briefs, the parties began discussing this issue in June of 2025. The HOA's attorney and counsel for the defendant met here in my office at Spencer Fain and discussed extensively the reason why plaintiff was incorrect that the club, in regards to its position that the club was not allowed to use the access road. Importantly, Your Honor, the club had used the access road for more than 20 years for golf course maintenance and improvement. Some reason plaintiffs believed that that 20-year history was incorrect, and so that meeting was held to inform them. In fact, defendant's counsel prepared a notebook 4 or 5 inches thick with all of the governing documents that plaintiff needed to consider before they were to pursue any type of claim. Following that meeting, repeated emails were exchanged between the HOA attorney and a counsel for defendant, inviting plaintiffs to engage in further discussion. In fact, there was an offer made to sit down and meet with their real estate lawyers rather than their litigators to make sure that the facts were fully understood and that the law was understood, because DC Ranch is a very complicated community, one that defendants counsel had many years of experience dealing with and was willing to share that experience with plaintiffs counsel. The last email from plaintiff's counsel says, "I'm waiting for instructions from my client. I'll get back to you." More than 6 months go by, Your Honor, and no responses received. No follow-up efforts to settle, no attempt to resolve these disputes. Rather, plaintiff ran to court and didn't just file a normal lawsuit. They filed a lawsuit that front loads attorney's fees. As you are very well aware, Your Honor, when a party seeks a preliminary injunction in TRO, it's effectively a trial of the case in the first month to 2 months of the complaint being filed. Necessarily, Spencer Fain, on behalf of defendants, recruited the appropriate lawyers to handle the significant briefing and trial hearing preparation that was required. Not just on the preliminary injunction in TRO, but also on the motion to dismiss. And I know, Your Honor, you said you're familiar with that, with the case's history, but I'll just remind the court, this is a case where the governing documents require mediation and face-to-face settlement discussions before a complaint is filed. So the motion to dismiss says this case is premature. This case should be resolved through mediation, not through filing a court case. Plaintiff, during the order to show cause hearing, converted this to a TRO, but Judge Gordon ordered the parties to engage in mediation. Unfortunately, the earliest we could arrange a mediator, the parties had already launched into the briefing and preparation for the case, and so fees were already being accrued. At that mediation, the parties started the groundwork for what's referred to in the briefing as the interim agreement. That interim agreement does not resolve any claims in this case. It does not grant the plaintiffs the relief that they were seeking, which is to bar the golf club from ever using the defendants from ever using the access road. All that did was place some operational limits on the golf club's use of the access road during what's called phase 1 of the construction. Importantly, Your Honor, in that agreement, in 2 places, both the opening paragraph on page 1 and paragraph 18, the parties are very clear. This agreement is not resolving the claims in the case, and it's not prejudicing anybody's positions. Specifically, it was not prejudicing defendants' argument that the whole case should be dismissed for failure to comply with the ADR provisions in the governing documents. If there were any doubt, Your Honor, the parties filed a stipulation on February 27th where they informed the court that there was no longer a need for a TRO and preliminary injunction hearing. However, the parties state, and I quote, "The interim settlement agreement does not resolve the underlying claims in this case. The parties further stipulate to continue oral argument on defendant's motion to dismiss." The case did, in fact, proceed on that basis towards the motion to dismiss, which was reset for oral argument. And approximately 72 hours before that oral argument would be held and potentially the case would be dismissed, plaintiffs threw in the towel, picked up their ball, and went home and said, "We're done litigating." Voluntary dismissal under Rule 41. But that decision does not prevent defendants from being the prevailing party, nor does it prevent this court from awarding attorney's fees. In fact, Arizona case law is very clear on that point. We cite the court to the Vicari case. We also cite the court to the Brick case. The Vicari case is almost directly on point. It's a published and controlling case where the plaintiff, after a motion to dismiss was filed a voluntary dismissal and argued that fees can't be awarded because the dismissal was voluntary and without prejudice. The court said, no, that's not correct. Even though you've dismissed your case, I still have discretion to award fees, and I'm going to do so here because it's appropriate under 12-341-01 test. The Britt case is similar, Your Honor, only in that case it was a dismissal for failure to prosecute. Counsel argues that's a distinguishing factor. Counsel for the plaintiffs argues that's a distinguishing factor that weighs in their favor. I would argue, Your Honor, it's the contrary. When a party intentionally dismisses for strategic purposes, there's at most a distinction without a difference there. The result is the same. The case dies without prejudice, leaving the defendant in the exact same position that they were in before the case was filed in the first place. Specific to my client, they now sit here with all of the issues unresolved, and they face potentially another lawsuit filed by plaintiff tomorrow where these exact same issues are raised again, and they have to incur the exact same fees litigating that. Thankfully, Arizona law is clear. Rule 41 is not a tool for plaintiffs to utilize to inflict harm upon defendants and then drop their case. It does allow them to cut off the fees in a case, but they still have to live with the consequences of their actions here, which is running to court, filing a complaint, and seeking a preliminary injunction, which caused the significant amount of fees that we're seeking to be awarded today. Your Honor, I'll quickly address the China doll factors, or I'm sorry, the associated indemnity factors, but I'll say for the court, the one that, and we've addressed them in the briefs, merits of plaintiff's claims. Again, we argue there were no merits, but this court doesn't need to decide that here because nobody's asking the court to go back and make substantive decisions on whether there was a trespass. That's not what's required. Plaintiff filed a complaint for trespass, sought a declaratory judgment, and brought a claim for nuisance. We, in our responsive pleadings, asked to have those dismissed, and that's the ultimate result here. That's what the court needs to be focused on. The avoidability of litigation, I've already discussed about that. The hardships to plaintiffs. In plaintiff's response, Your Honor, they argue that there's potentially a weighing in their favor on the hardship, but the law is clear. If a party opposing a fee app wants to claim a hardship, they are the ones who have the burden to come forward with it. We've pointed out here that plaintiffs built a $6 million house on a golf course. That I think weighs strongly in favor of no hardship, but most importantly, plaintiffs didn't provide any evidence. So we would submit, Your Honor, that the degree of success is 100% in our favor, and the relief that we obtained is a full dismissal. All of those things are exactly what the golf course sought when they opposed this case in the first place. Lastly, I'll talk about the arguments.
Oh, go ahead, Mr. Garrett.
Can I just address quickly, Your Honor, the arguments that the fees should be reduced? First and foremost, Your Honor, the staffing of this case reflects an appropriate staffing of real estate attorneys with professional experience with these CC&Rs, and then litigation team that was required to be recruited and formed to address the two issues, a preliminary injunction and a motion to dismiss. You could see from the time entries that Ms. Awad was responsible for the motion to dismiss, and Amy was responsible for the briefing on the preliminary injunction, and I was responsible for the supervision of all that. The two partners referenced that are not part of the litigation team are real estate professionals. They billed a total of 30 hours combined, 10 hours for Ms. Stoll and 20 hours for Mr. Burr. None of that is inappropriate staffing in light of the fact that plaintiffs were the ones who created this fire drill. I'll also want to discuss the block billing, Your Honor. It's interesting that the only example plaintiffs use in their response is actually not block billing. It's one that each task is separately assigned a time entry. I will acknowledge, Your Honor, that there are some instances of block billing in the fee applications that are submitted. I'll represent to the court that I've reviewed all time entries. I've offered an affidavit that they're all reasonable. But if the court wants to look at those, I believe the court can evaluate each of them and see that the time charged for the task performed, despite there being multiple tasks included in that time entry, is still reasonable, and that the court shouldn't apply any reduction for the block billing. But at most, the court should apply a 10 or 20% reduction only for those block billed time entries. All of the other time entries, including the time spent on the preliminary injunction and TRO, are all properly awarded under ARS 12-34101.